Good afternoon, class.
Good afternoon, Sir Benjamin.
Yes, this is just a brief session that I am delivering at the request of the class representative, who indicated to me that some students would like to have had a little more on 4 particular topics. But before we go there, just let me indicate that for the purposes of the exam, I'm directing your attention to actus reus, and in particular, dealing with omissions. That will feature, as also will feature strict liability, but we would like you to focus on what you would consider to be the rationale behind the principles and also the criticisms that you can make of these principles. And that's what the focus would be in relation to that. So when you talk about omissions, I think we all accept that there is no liability for failure to act. That is the general rule. Acts have to be positive acts for the purposes of the actus reus. But there are exceptions that encompass omissions to act. So in the absence of a duty to act, one can't have any criminal liability. But the omission may become the actus reus on the basis of certain principles. For instance, statutory duty, contractual liability. There may be a duty imposed by the common law as dictated by decided cases. In such circumstances where a duty is imposed, the actus reus is satisfied by the omission. And so therefore, it has to be rooted in the cases. There are some cases where a statute would expressly or impliedly create an offense of omission. And if that is the case, the language of the statute would point out the person who is under the duty to act. In fact, in France, in the French Criminal Code, there are provisions that specifically speak to omissions to act. The Law Commission in England has, in fact, if you read Smith and Hogan, the Law Commission in England has suggested that there should be legislation that encompasses omissions, but it has never been adopted in England. Far less has there been any talk of such a nature in Guyana and in the region. So the common law very rarely imposes liability purely on omissions. There are some exceptions, of course, misprision of felony, which means failing to report knowledge of a felony to the appropriate authorities, and that's a misdemeanor under the common law. So if you conceal a serious crime, though you're not a party to it, under the common law, you can be made responsible. Now, I'm not going to go through all the cases, but I think you know, you're familiar with some of the cases from the worksheets. There's, of course, the case of Pitwood, which comes under the category of a duty to arrive out of contract. Of course, the car crossing the train line because the worker failed to close the gates, at the railway crossing. And in that case, Mr. Justice Wright held that the defendant was under contractual duty to close the gate and took the view that the defendant was employed by his company with the responsibility for protecting the public. So therefore, the omission to perform this obligation was capable of constituting the actus reus for murder. And in that case, the court, Mr. Justice Wright, relied on the case of R.V. Inston. That's a case where the defendant lived with his aged aunt, and who, when she began to live with him, was very healthy, but shortly before her death, she became unwell. And in the last few days of her life, she developed gangrene in her leg, and she couldn't care for herself, and she couldn't move around even to ask for help. Now, the defendant with whom she lived, he knew of her condition, and he did nothing to help her, didn't feed her, didn't go and get any help, and he was charged and convicted for manslaughter. And that conviction was affirmed, and the court said that the duty arose from the assumption of care for the helpless and infirm. Now, that didn't arise out of contract, but the court in Pittwood relied on that case. And then there are all the other cases. R.V. Miller, a case where the appellant had lit a cigarette when he fell asleep. I lit a cigarette and fell asleep. Woke up with the mattress, had caught a fire. He didn't do anything. All he did was go to another room and continue to sleep. And the building was destroyed by fire, and he was held responsible for arson. Then there was the case of Stone and Robinson. That was in the category of care for a blood relative. Now, there is a case, all these cases you can consider with a view to being able to criticize them and to decide whether they go far enough. There is a case that involves medical treatment, Airedale National Health Trust versus Bland, where the person was a vegetable, and the issue was whether the court should give permission to withdraw a feeding tube. The court did grant permission, and what they did is draw a distinction between what could be considered omissions, such as failing to feed the patient, and those that could be considered offenses that were positive acts and could not be clearly committed by omission. So you see that distinction that was made there in the Airedale case. Now, do you have any questions on omissions?
No, sir.
No, sir. So far, we're okay with the explanation that you gave for omissions.
Okay.
Excuse me, sir. Question.
Yes.
I don't think I heard it too clearly. You said to learn the criticisms and rationale for omissions and strict liability?
Yes.
Okay, sir.
I think anybody with a good memory can regurgitate the cases and the principles. They're very straightforward. What we would want for you is to tell us why you think the principles don't go far enough, or whether there should be some kind of reform, whether there should be more liability for omissions. And I gave you some examples. Smith and Hogan has some commentary on that. Okay. Now, I want you to draw to your attention where strict liability is concerned. Just a moment. In my hurry to leave the office, I forgot most of my notes. Anyway. Strict liability, of course, comes from the principle that all crimes should be governed by actus reus and mens rea. And so, as Lord Reed said in Smith and Parsley, there has been a presumption for many centuries that Parliament did not intend to make criminals of persons who were not blameworthy in what they did. And you will see on the worksheet a number of articles that are set out there. You'll find them in LexisNexis that discuss. One of them is the value of strict liability. You'll find that in Criminal Law Review 1969. And these question the principles that have arisen on the cases in relation to strict liability. I think by now you would realize, in her lecture, Magistrate Judge did her best to highlight the arguments for and against strict liability. And so you have to ask yourself whether strict liability can create an unjust result, and whether, in some cases, it's necessary to have strict liability at all. Because these are governed by societal matters of societal policy. And there are arguments on both sides of the coin. I read a critique in Elliott and Woods of Cases and Materials in Criminal Law, and it discussed the whole question of whether some of these regulatory offenses in fact do create greater administrative efficiency, and went on to point out that there are arguments on both sides of the coin. So the focus should be on how would you argue for or against strict liability, being fully aware as to what the principles are. I think you can perhaps go back to the study guide and see where Magistrate George set out some of the cases that dealt with matters of policy. Case such as Sweet and Parsley, which is the main case. And then there was the case of Gammon against the AG for Hong Kong, Alpha Cell against Woodward. The whole social danger that follows upon breaches. In this regard, we look at drug offenses, road accidents, and matters of pollution. Drug offenses, you can look at Warner against the Metropolitan Police Commissioner. And of course, the Alpha Cell case deals with regulatory offenses of strict liability. And then some argue that some of these crimes are not really crimes, and they call them quasi-crimes. And Mr. Justice Wright, in the case of Sherris and Berutson, made that point. He distinguished class of cases which are not criminal in any real sense, but are acts which in the public interest are prohibited by way of a penalty. So that's the focus we want you to have for strict liability. Are there any questions?
No, sir, that was clear.
Not at the moment, sir.
I'm not hearing you. Could you
Not at
speak
the
up?
moment.
Okay, I'm not hearing you. Can I proceed?
Yes, sir.
Okay, I'm not hearing anybody clearly there. Yeah. Okay. Now, from the email I got, I saw there was a request to what constitutes participation in an offense. Well, that is a very, very wide, that encapsulates the whole participation in crimes. As you know, there were 3 subjects that were dealt with. apart from participation through an agent, we dealt with joint enterprise. And that's where the case of Georgie was mentioned. As you know, Georgie overruled the case of Chang Wing Soo, which was a Privy Council case, because the Supreme Court in the UK took the position that was wrongly decided. That they used the euphemistic expression, court took a wrong turn. In the case of Georgie, two persons were out drinking and taking drugs, and they became intoxicated and aggressive. And they went to a woman's house and told her to leave but she told them to leave before her boyfriend came back. They told her they weren't afraid of him and they would sort him out, but they left nevertheless. But they went back afterwards. And when they went back, the boyfriend was there. So she phoned one of the two persons, the two defendants, and told him to go and get the other person, which he did. And they went back to the house. And one of them went in, had a confrontation with the boyfriend, and took a knife from the kitchen. And while he was outside, he had a bottle. The other one was outside, damaging the car with a bottle. And the boyfriend was trying to get the one who seized the knife to leave. The one who was outside damaging the car, he was shouting threats at the woman in the house, and what he would do with the bottle and what he wouldn't do with it. And the one who was in the house ended up stabbing the boyfriend in the throat and killed him, and they were both convicted of murder. And as was consistent with Chang Wing Soo and the case that went before Chang Wing Soo of Powell and English, they were convicted, and the jury was told that if they were satisfied that the one who was outside with the bottle participated in the attack by encouraging the one who used the knife, and realized when doing so that the one with the knife might use the knife to stab the deceased with intent to cause him really serious harm, then they ought to convict. They appealed to the Court of Appeal, it was dismissed, and the Court of Appeal, the matter was taken to the Supreme Court. So in that case, they revisited this whole principle of parasitic access liability. And that's where they concluded that the Privy Council in Chang Wing Soo and the House of Lords in Powell and English have taken a wrong turn. Now let me go back to my notes just a moment. Now, what the court said in the Supreme Court, and that judgment was delivered jointly by Lord Hughes and Lord Tolson. They said in cases of alleged secondary participation, there are likely to be two issues. One is whether the defendant was in fact a participant. That is, whether he assisted or encouraged the commission of the crime. And that could take several forms. And it could include, in fact, providing support by contributing in perhaps a gang to the force of numbers. And the second issue that is likely to be raised is whether the accessory intended to encourage or assist the main perpetrator to commit the crime, acting with whatever mental element the offense is required of the main perpetrator. So that if the crime requires a particular intent, then the accessory must intend to assist the main perpetrator to act with the same intent. So that if the accessory encourages the main perpetrator to take someone's bicycle without permission of the owner and to return it after it has been used, but the main perpetrator decides to keep it, the main perpetrator would be guilty of theft. But the lesser perpetrator, that is the accessory, would be guilty of an unauthorized taking. So the important thing here is to concentrate on the mens rea. In Chang Win Su, what they said that there was an overwhelming case inferring that the appellants foresaw the likelihood of resistance and that their plan included the possible use of knives caused serious harm. And it's on that basis that the Privy Council upheld the submission and the conviction. And that same position was taken in Howell and English. But the court in Joji took a different position. They said in such a circumstance, the secondary party, before he can be convicted alongside the main perpetrator, must have the same mens rea as is the case in as is the case for the main perpetrator. Now, I don't know if you can remember Chang Wing Su, but in Chang Wing Su, the appellant and two other persons went into some premises in Hong Kong to collect a debt. Two of them knew that some of them were carrying knives. And when they opened and pushed their way, those that had the knives drew the knives. One guarded the wife and two others attacked the husband, and the husband was stabbed to death. The attackers were also injured, but the wife, she couldn't see who inflicted the stab wounds, and one of them, in fact, cut her when he was leaving the premises, and she couldn't even say who did that. Now, the appellant and the one who was guarding the wife, they denied that they had stabbed the husband. And the third person, he raised self-defense. And they all had alleged that the husband had attacked them. But they were all charged and convicted of murder. And the issue is whether foresight of the possibility that the principal may commit a crime which went beyond the plan was sufficient mens rea to justify a conviction under accessory liability. Under Chang Wing Su, they held it was sufficient for conviction under the principle of joint enterprise that a person foresees that the principal may commit an offense which goes beyond the plan, even if he did not intend that the offense be carried out. What they held is that foresight was sufficient. Now, in Georgia, the Supreme Court is asked to review what was decided in Chang Wing Su and Powell in English. And they examined the whole line of cases all leading up to Chang Wing Su. And those cases established that for the defendant to be guilty as an accessory, the defendant must have intended to encourage or assist in the crime. Now, the Supreme Court rejected that principle of foresight, and they said it was erroneous and based on an incomplete reading of the previous case law, coupled with generalized and questionable policy arguments. And I would direct your attention to paragraph 79 of the judgment. And what the law lord said is as follows. It will be apparent from what we have said that we do not consider that the Chang Wing Su principle can be supported, except on the basis that it has been decided and followed at the highest level. In plain terms, our analysis leads to the conclusion that the introduction of principle was based on an incomplete and in some respects erroneous reading of the previous case law, coupled with generalized and questionable policy arguments. We recognize the significance of reversing the statement principle that has been made and followed by the Privy Council and the House of Lords on a number of occasions. And we considered right to do so for several reasons. First of all, we've had the benefit of a much fuller analysis than on previous occasions when the topic was considered. Secondly, it cannot be said that the law is now well established and working satisfactorily. It remains highly controversial and a continuing source of difficulty for trial judges. It has also led to a large number of appeals. Thirdly, secondary liability is an important part of the common law, and if a wrong turn has been taken, it should be corrected. And fourthly, in the common law, foresight of what might happen is ordinary no more than evidence from which a jury can infer the presence of a requisite intention. And let me pause here to say that what they're saying is that the secondary party cannot be convicted on the basis that he had foresight that the main perpetrator might commit the crime. It has to be more than that. He has to have the same mens rea. They went on to say it may be strong evidence, that is, the issue of foresight, but its adoption as a test for the mental element for murder in the case of a secondary party is a serious and anomalous departure from the main rule, which results in overextension of the law of murder and reduction of the law of manslaughter. So what they did not allow was the Chang Wing Su principle that extended liability for murder to a secondary party on the basis of a lesser degree of culpability, that is foresight. For the purposes of Joji, they said that it has to be no less than the very intention that the main perpetrator possessed. It may be that foresight would lead the jury to believe that the necessary foresight was present, the requisite intention was present, but foresight by itself was not enough for the secondary party to be convicted of murder. So that's the distinction between Chang Wing Su and Joji. Let me see what. Yes, parasitic accessory liability. In short, it means joint enterprise. Are there any questions?
No, sir, it was clear. Sir, I have a bit of a silly question that is not impertinent to the what you just explained because that was self-explanatory. In the problem question, it will often label the defendants as A, B, C, D, E, F. And to make it simple for me, I would give them names. Would that be okay to do in the exam?
Yes, provided that you explain that you have given D a name, E a name, F a name.
I do, sir. Thank you.
I can vaguely recall that in the problem question, there was an A who did injury to B, C, D, E, and F, was it? I think I recall. Yes? Anyhow, yeah. All right, now what else is there? No, the whole question of withdrawal. I didn't quite understand whether we meant, Ms. Phillips, could you clarify whether we meant here withdrawal in the sense of repentance?
Yes, sir. The person was asking for withdrawal in that sense, from what I could have gathered from what he told me. But that's what I
But,
don't understand.
but I don't foresee that there is any difficulty in that, in withdrawal. Those who were in my tutorial group, we went into that in some detail in the in the tutorial. Now let me go back a bit and talk a little bit about attempt, because I realized from previous exams that persons have been confusing English law with the common law that's applicable in Guyana. Now, with English law, there was the Criminal Attempts Act of 1981, and Section 1.1 defined an attempt as an act that is more than merely preparatory for an offense. I think we all know that. But that is the actus reus as is set out in the Criminal Attempts Act. It applies in the UK. It does not apply in Guyana. Guyana is governed by the common law. And there are a number of cases that you need to look at. The first case is Eagleton. And that case was followed by another case of, see if I remember the name of the case, Stonehouse. And in that case, I think it's a 1978 case, I'm not sure. I think it's a 1978 case. And in that case, the judge said, I think it's Lord Diplock, he said that the person must have crossed the Rubicon and burnt their boats. In other words, they must have done everything in advance of actually committing the crime. So please look at those cases and make sure you draw the distinction between an attempt under the common law and an attempt under English law. Now, as regards withdrawal, there are cases on the worksheet. And in essence, what the cases say is that the withdrawal must be an effective withdrawal in a timely fashion. And in the case of Grundy, it says it must take place before the offense is committed and the communication must be unequivocal. That's the case of Grundy, 1977. So that if you have an arrangement with someone, if there's a conspiracy, and two of you are arranged to go and do something, the mere fact that you don't turn up is not enough. You have to have effectively withdrawn by indicating to the other person that you are no longer part of the transaction. And the case of Rook of 1993 makes that point. And the case of Becerra and Cooper goes even further. It says that when the offense is in progress, if you want to withdraw and you want to countermand or repent, you have to do something physical. It's not enough for you to, and as in the case of Becerra and Cooper, the fellow, when they went to burgle the place, and when the owner showed up, he simply just jumped out the window and ran away and saying, "Let's go." That was found to be not enough. He needed to have done something physical, perhaps drag the other person away, or tell the person, "I am not part of this," because the other person went on to commit murder. So there must be a timely and effective withdrawal before you can say that there has been repentance or withdrawal. So those three cases would assist in that regard.
Sir, if we use Becerra, we don't have to use Grundy, or do we use both?
It's better to use Grundy and Becerra and Cooper. But I found that Becerra and Cooper dealt with the position adequately. There's also a Guyanese case that I'm trying to locate. A Guyanese case that discusses Becerra and Cooper. Chancellor Crane discussed it. Becerra and Cooper. I'll try and locate it overnight and send it to Ms. Phillips, and she'll circulate it to you. It'll just take you a few minutes to read it. Okay, and I think that covers the four topics that you asked about. For the purposes of the exam, I indicated to you, you deal with actus reus by way of omissions, strict liability, then transferred malice. Then there's participation and discussing the case of Joji. Causation, both factual and legal. And also, I dealt with attempts at some length. Attempts and the impossibility of carrying out an attempt.
So, sir, so actus reus and mens rea, they're going to be two separate questions. They don't come in underneath one heading.
Yeah, they'll be separate.
Okay, sir, thank you.
Okay, so have a good evening and best of luck in your exam.
Thank you, sir.